it's a long-term relationship.
It's estate planning, but it's personal. And we're able to minister to that person and give them counsel and give them guidance and let them know they're not alone.
When we first walked in the door here, we just felt so at ease. They greeted us really in a wonderful, welcoming way.
We just had a much more positive experience than we have had elsewhere.
One of the things that we are known for is the fact that we have always put clients and their needs first. So service is extremely important to us.
As I was getting older, clients were looking at me and saying, hey, your hair's getting gray. I think you're going to retire. And I looked for years for a company that would service clients in the same manner that I felt that I was serving my clients. And I finally found Copenhagen.
I've learned over the years that you do business with people you like and you trust, whether it's the gardener you're hiring or it's your surgeon and certainly an attorney. And what we found when we walked through the door was that pretty much immediately we loved the people here. And that's why we chose Copenhagen.
Without our team of people, we're nothing. We have the best attorneys you can ask for, the greatest education and credentials, but without that team of people, we're not anything.
So not only are you servicing the client, but the fact that everyone cares about each other unites us as one group, and it's pretty exciting to be on a team like this.
The Copenhagen firm is an outstanding firm. They are very generous, they are the most kind people, and they have done an outstanding job for my husband and I.
It was some 20 years ago. We made an appointment and we came to the office, and that's when we met Larry Copenhagen, who was an outstanding man.
We have become a family over the years.
I was really taken by his hospitality, his warmness, and that's how we became friends.
We're keeping that in mind when we're bringing new staff on board, that they recognize that in order of priority, it's serving first. So it's not just about their technical skill, it's really about making sure that they're a good fit culturally, and that's what's ultimately going to lead to a successful transition of Wood's legacy.
Someday I'm not going to be here anymore, but the people who have relied on our representation will be, and I know the people that are the clients of Copenhagen will be taken care of in the future just as well by the other attorneys.
When you hear from our clients, they feel like they're cared for here, and I think to come in and want to change that, I came here because I want to care for them and I want to keep this legacy going.
It gives you a great sense of satisfaction that what you're providing to your client cannot be surpassed. Maybe equaled by some law firms, but definitely not surpassed.
I'm very, very confident in the work that they do here, and my experience has been tremendous.
I believe sincerely when I look at the future possibilities of this firm that we can impact thousands of families, just like we have for the last 40 years.
Every night when I go home and I look in that same mirror, I can say to myself, you had an impact in some people's lives today that will make their lives better. Now, how does it get any better than that in life?
Good morning. Can everybody, especially in the back, hear me? Hopefully, yes? Okay, perfect. Well, thank you guys for being here. For those of you who have been to this seminar before, you're probably noting a little bit of a venue change. So there was a few events on site, so we are in this beautiful, beautiful sanctuary. All right. So we are going to get everybody started. So as people file in, if you don't know who we are, I'll step up here because I'm a little short apparently. If you don't know who we are, we're going to do a little introduction into the Copenhagen Law Firm. For those of you who have been with us, you may notice there are a few new faces. One thing I do want to note, a little housekeeping. The packets that you should have received right after you checked in have the slides that we're going over, and they also have a few additional slides that will not be up on the screen. For all of this information, we generally speaking have a webinar, a video, a blog, something on our website that will cover the topic in more detail. So you are welcome to go to copenhagen.com. There's a resources tab that will have all of those videos available. There's also at the back of the packet a QR page, so it can take you to specific videos about specific topics. Because the purpose of today is to do a pretty comprehensive overview of what we do and letting you know what has changed and what you may need to think about. But it's not going to get into everything that's specific to you. So what we also encourage is, because you are attending today, you're entitled to a free consultation if you have not already met with us this year, which, given it's February, I'm guessing none of you have yet. So I encourage you to take advantage of those free consultations as well. Still want to double check volume. Can you guys understand me with it reverbing a little? Okay, perfect. All right, so the first thing I want to highlight is our group of attorneys. So as I mentioned, if you have not seen us in a few years, there's likely a few new faces. Our team has grown fairly significantly. But what this also shows you is that Kopenberger does not just do the estate planning and foundation part of this process, but we also have an estate administration department. So what that means is, after a loved one passes away, whether it's a Kopenberger trust or a non-Kopenberger trust, we can assist and step in and help with that administration, which is a crucial part of the estate planning process. We also have a business and tax department. So if you have a rental property, if you have a small business, if you have a large business, you have additional tax questions, we have a very comprehensive team that has advanced information and knowledge that can go further, again, than your revocable trust planning that I primarily handle. We also have an estate litigation department. Now, with that, everything I talk about today, for the most part, is how to avoid court. We don't want people to end up in court, but unfortunately we know that sometimes, no matter how much you plan, people fight. Things happen. Beneficiaries can get upset with each other, and so we have Elaine who can walk alongside whoever needs her when it comes to litigation matters. But again, the focus of today is how do we avoid court as much as possible. One of the things I also encourage you to do is use those packets to take notes. As I mentioned, with those free consultations, you are entitled to those for being here, and a lot of times bringing those packets is where we can really hone in on what were the things that mattered to you today, what were the questions that got brought up today. So I do encourage you to use those as a resource as well. So if you already have a trust, this first section is going to be more of a refresher on what the documents you have are, why they're so important, but it's also going to highlight making sure that they stay up to date. For those of you who do not have documents, this is going to be a great course in why do you need certain estate planning documents. Lloyd, before I get started, do you want to say anything?
I sure do.
All right, perfect. If you don't know, this is Lloyd Kopenberger, the founder and owner of our firm.
First of all, let me thank all of you for being here today. Let me ask a couple of real quick questions before we go. How many of you suffered loss in the Pasadena fires? Okay. First of all, we give you our condolences and we give you our prayers. I know the tragedy that occurred there, and Kopenberger have many clients in the Altadena area, and we were very much concerned when that fire occurred, and it was very difficult to find out who had been affected and who had not. The second thing I want to say is that today is a special day. It's special because you're going to get to meet the people that we've been training for several years to be here for you when the time comes that Larry and James and I are no longer able to be with you. I consider every person that is a client of Kopenberger as a gift from God. And that means we have a responsibility to take care of your needs as long as you have needs to be met. And so you're going to be meeting some very wonderful young attorneys during this session today that are people who share our values and who have committed to be there for you when the time comes that we're no longer given that privilege. And so before we go any further, I want to do two things. First, I want to ask you to pray with me for the people in Altadena. And the second thing is I want you to hold up James Kosleroff in your prayers. He lost his father this week, and he's dealing with that family necessity as well as the grief that many of us have already experienced when we've lost our parents. And it doesn't matter how old you are or how mature you think you are, losing a parent is a special loss. And James is no different than any of us on that. So without any further delay, because we're under time pressures because of some glitches that were made in the scheduling here at the church, but let me ask you to join with me silently praying for the people in Pasadena and for James Kosaroff in particular. Heavenly Father, we come before you today and we ask you to comfort and give peace to those who have suffered such enormous losses of personal things and family mementos and all the things in life that remind us of the past and give us hope for the future. And we ask that you give them the strength and the comfort to go forward and restore those areas of their life that have been damaged and lost. And Lord, we ask you to touch James Kosaroff and give him strength and give him wisdom as he guides his family through this time of grief and time of loss. And we ask all these things in the name of Jesus Christ. Amen. Now, without any further delay, I'm going to turn you back to one of the young attorneys that I was telling you about. Some of you have already had the privilege of meeting and talking to Victoria, but Victoria is just one of a number of very fine attorneys who have been part of our firm, who've been trained, and who are doing marvelous work. And by the way, I haven't quit, but you got to ask for me. And then you got to twist an arm or two. But I'll be honored to have the privilege of serving you as long as God gives me the strength to do so. Victoria?
Thank you. Thank you, Lloyd. Going back to the housekeeping, if you did lose your estate, if you had a Kopenbarger trust and you did lose those estate planning documents in the fire, we have my legal assistant, Isabel, outside. She's at a small table just to the right where she can print your planning documents. So if that is something that you need, please let us know and we can get you taken care of today. So going back into the why do you need an estate plan, what do those documents entail, and if you already have them, what do you need to be paying attention to? One thing when you meet with an estate planner is that it should be a comprehensive set of documents that the estate planner is talking to you about. If you have a planner who doesn't touch on each one of these documents in some way, unfortunately you are being left vulnerable, your estate is being left vulnerable, and or your family is being left vulnerable, and you may not realize it. So we want to make sure that when you walk away from here today, you understand again that this needs to be a comprehensive set of documents, not just one or two. So the first one that you have to have if you are over the age of 18 is an advanced healthcare directive. The reason I say you have to have one is as soon as you turned 18, everyone lost an automatic right to make medical decisions for you if you couldn't make them for yourself. So what does that mean in practicality? It means your spouse doesn't have an automatic right to make medical decisions if you can't give that permission. Your children, your parents, truly no one has an automatic right. So it is imperative that you have something in writing so that if you are in the middle of a surgery, or you're in a car accident and you're rushed in unconscious, or you're at the end of your life and decisions are needing to be made, you have in writing who that person is that can advocate for you. Now, it is also imperative that you have one that was done after 2004. So for your healthcare directives, if you have a pre-2004 document, it is not going to be accepted as valid because privacy laws changed in 2004 and there has to be specific provisions in yours to make sure that they're still valid and accepted. The other thing is you want a comprehensive healthcare directive. There are free versions, there are physician-provided versions, but in most cases they are not comprehensive. So why is that a problem? First reason is if it's not comprehensive, if it doesn't go into decision making of what do you want at the end of your life? Do you want life support? Do you want organ donation? Do you want burial versus cremation? If you don't put those things in writing, your wishes may not be carried out because the person does not know what you would have wanted. The second thing is by putting it in writing and answering those questions ahead of time, you're gifting something to the person who has to make that decision. You are allowing them to not second guess what would you have wanted? I have been in the position of unfortunately having to make a life support decision for a family member, and it was my grandma. And the best gift she frankly could have left in that horrible time and getting asked that horrible question is she had a healthcare where she had signed, no, I do not want life support. So while it's still an impossible decision in so many ways, and it's still a grief-stricken decision, it was easy because I knew I was carrying out what she wanted and I did not have to think. So again, it not only ensures protection for you, but it gives that peace of mind for your family. Now, there is one important thing to note if you again have a healthcare directive, especially if it was provided by Koppenberger. Kaiser has in particular gotten extremely strict on their requiring specific language that indicates when the healthcare becomes effective. Now, this has been frustrating because ours have language that shows when it is effective, but it is not specific enough for them. So they started rejecting them. Kaiser is typically a leader in the field as far as what language is required, and so we unfortunately expect that other hospitals are shortly going to require this as well. The great news is we have a simple addendum that we can put in with your healthcare directive that puts the necessary language in accordance so that it is accepted. And if you have a new healthcare directive with us from this point forward, it will automatically have that language in it. So we can absolutely get it taken care of. It's not hard for us to get done and efficiently get done for you, but it does need to be done, especially if you have Kaiser at this point. The next document that you need if you are over 18 is a durable power or financial power of attorney. So the first one deals with medical decisions. The durable power of attorney deals with your money. So why is that important? Well, numerous reasons. If you are unable to make your financial decisions or pay your bills, that, as we all know, doesn't mean that the bills stop. So you have to, again, have it in writing who has the authority to manage your bank accounts, your property, and your retirement accounts. I want to really emphasize the retirement accounts. A lot of times we'll hear from spouses, well, why do I need this? My spouse is on as a co-owner, so don't they have an automatic right? And that is correct for assets that they co-own. But things like your retirement, your life insurance, those things are on you. Your spouse is not an owner, they are generally a beneficiary, which means if you are incapacitated and they don't have a written authority to manage the money while you're alive but unwell, they can't touch the funds to take care of you or to take care of obligations that the two of you have. So you still need this document in effect. Again, though, I want to say if you already have one, these need to have been done in the last 5 years. Financial institutions after COVID were really cracking down on financial fraud and elder abuse. They unfortunately saw incapacity, as we all did. Cases go up, which meant an increase in elder abuse and financial fraud. And so their way of combating it was to say, if this document was not done in the last 5 years, we're counting it as outdated and are not accepting them. And what we very bluntly tell our clients is, you will frankly pay us a lot less to keep this document updated than for us to have to fight with the bank for them to keep it enforced or ultimately go to court to force the bank to enforce the document. So keeping these updated, again, ensures that your bills keep being paid on time, that the financial wheels keep turning if you can't, but it really helps the family to have this in place so that they're not scrambling trying to figure out, how do I now take care of mom or dad? Do I have to pay out of pocket? How do I get access to their resources? They have the access necessary to take care of you. This next document is not a need for everybody. It's only going to be a need for a specific group of people. We ran into the issue about a year ago where one of our clients had a daughter who, unfortunately, she had a mental health illness that had been being maintained. And unfortunately, there was a temporary, I'll say, lapse in medication. She was taken into the hospital. The hospital checked her into a psychiatric facility. Her parents did not. Now, this is an adult child. The child had a healthcare directive up until that point that it allowed her parents to be her advocates, to be her powers of attorney with no issue. The psychiatric facility said, no, we will not accept that document. You have to have a psychiatric healthcare directive. So, this again is not universally needed, but if you have yourself a mental health condition where there could be the need for a psychiatric facility, or if you know somebody who may end up needing that, come and talk to us about, is this the right document for you? This is something that, again, we created almost immediately upon hearing this story. We researched it, spent hours putting time into creating this. So we do have a document to now cover people in those circumstances, but it's likely not something you have done if you haven't seen us in the last year. So why in part, though, I've talked about the healthcare directive and the power of attorney for finance, and I keep saying it is a need. And I said at the very beginning, a lot of what I talk about is avoiding court. So one of the crucial issues is when you do not have a healthcare directive or that financial power of attorney in place, and somebody becomes incapacitated, unless, again, you have been given you had given a verbal authority to the physician ahead of time, or there was something on file where you're a co-owner of an asset, the issue would be if you don't have these documents, we have to go to court for them to give somebody the authority to take care of you and take care of the money. So not having those two simple documents means now at your most vulnerable and at the time when your family is probably their most stressed and scrambling, we now have to add in the factor of court, which is time-consuming, it is expensive, and it does not make the situation better. So again, I keep hammering this home. If you do not have valid healthcare directives or powers of attorney for finance, now is the time to make sure those get put in place. The next question we want to address is, do you need a will or do you need a trust? So this is a very foundational, fundamental question that needs to be answered correctly, because if it is answered incorrectly, again, there can be the risk of court after somebody passes away. So you would qualify under the protection of a will if you do not own a piece of real property, so you don't own a piece of land, you don't own the home, you do not have real estate, and or you have less than $184,000. If either of those two conditions is not applicable to you, then a will is not going to be enough to keep your estate out of court. So it is imperative that you again have an attorney who dives beyond just the family, but really will look at the assets comprehensively. I mentioned court, so this is what is called probate court. So if you were to pass away, and let's say you owned a home and you only had a will, the court basically looks at that and says your estate is too complex to be dealt with without our involvement, so now we have to institute probate court. Probate court, and you'll hear from one of our administration attorneys today, probate it's frustrating, frankly. It's more expensive, it's more time-consuming, everything is on the court's rules, everything is in their control. The family doesn't get to dictate what does or does not happen. We don't get to control what does or doesn't happen. The court, ultimately, they have their rules, and everybody involved in the estate has to follow them. So when we talk especially about the time and the cost loss that comes from probate, we really cannot understate the effect that that can have on somebody's estate and family. The length of time with probate, especially after COVID and the courts temporarily shutting down, the probate time frame got longer and longer and longer. A simple probate can take 2 to 5 years. A complex probate can take more than that. And again, that is because everything is on the court's calendar. It's based on do they have availability. And unfortunately, your situation is not the only one that they are dealing with. And so depending on their docket, depends on how fast or slow that case can move. The other issue is the cost. So the probate court puts the cost or the fees on the entire gross value of your estate. What that means is if you have a home that is valued at $1.3 million, they do not care what your equity in that home is. They don't care if you owned $100,000 in equity or you owned the entire thing. The fee is on the entirety of that house value. Now you'll see attorney's fees at the very top for that $1.3 million home, that our attorney's fees are $26,000. Couple things there. One, we don't set those. That is a court statutory, that it's their level, it's what they set that we end up taking as a fee. The other thing is a lot of people question, well, why, if you could get $26,000 off an estate, are you guys standing up here and telling us to avoid that? Doesn't that fee benefit you more than a revocable trust would? If all Kopenberger cared about was money, probate could be the way we would go. But at the end of the day, Lloyd started this firm because he truly cares about his clients, and he knows that probate is not in our clients' best interest. It is something to avoid if possible. And so that is where we talk about how are the ways that you can avoid probate and how your family can avoid probate and not incur these unnecessary fees that deplete the legacy you had built. So that is when, yes?
How do the courts know when a person dies to reach out to them, how does that happen with the process?
So the question was how does the court know when someone has died? How does that get initiated? The court doesn't. Someone has to go and file a probate process. So typically it's a family member. If you had a will, it's called an executor, but somebody has to actually initiate it. Yeah. So avoiding probate, the bread and butter of what we talk about is living trusts. So trusts are there to essentially say to the court and to the state, you had set up terms that were detailed enough, the court does not have to get involved. You have answered all of the questions ahead of time that the court says your will did not. So you are what is called, if you create the trust, you are known as a settlor, which truly is a fancy way of saying creator. You are also most likely the initial trustee. So that means you'll continue managing things just like you did without a trust. But it also means you can now name what is called a successor trustee. This is a person who steps in to manage when you no longer can, whether due to incapacity or now you've passed away and somebody needs to help wrap everything up and get the assets to where you have laid out. And those are the people called the beneficiaries. Now the great thing with a trust is you get to dictate the terms of the beneficiaries. In court, they have a set list of who gets it, and basically the person just gets to take it and that's that. But not all beneficiaries are created equal, and by that I mean some people may be overspenders, and you want to build protection around them just depleting their inheritance. Some people may have substance abuse issues. You may want to leave them something, but not necessarily let them have the money to use for that substance abuse. Could be a special needs beneficiary, where you would want to leave them something, but you don't want them to lose their government benefits. There's a ton of different reasons that we would look at additional protections around beneficiaries, and your trust allows you to do that. The court in so many cases does not, and it can then have catastrophic effects. So not only though does a trust allow you to avoid probate, it also allows for advanced tax planning. Now what I hear and what we hear pretty consistently is, I have a modest estate, do I really even need an estate plan, but why are you talking to me about tax planning? I'm not at the uber 1% of wealth. The problem with taxes, as all of you know, is they apply to us in many ways whether we want them to or not, and most of us say not. So when we're talking about tax planning, what we're really wanting to focus on is that you, your estate, and your family do not pay 1 penny more in taxes than is legally required. Pretty much every single tax law has a loophole built in for the for the person who created that law. And Lloyd, when he started this firm and what he has expected from the attorneys since, is that we're going to dive into those tax laws to find those loopholes to apply to our clients. And so we talk about property taxes, capital gains taxes. We talk about, at this point, what happens with your retirement accounts when you pass away. Again, taxes affect us all in many ways we may not realize. And your trust allows you to build in those protections that, again, are not there if you do not have one in place. Now, one of the fundamental questions that we hear when we're setting up a trust is, okay, I love my kids, but I don't necessarily want them to be the ones managing the money. That could be they have conflict, that could be they may not be the best money managers. There's a variety of different reasons people are concerned about their children being their trustees. But a lot of times the problem becomes, then who will be the money manager if you are no longer here? Who is that person going to be? So you have a few alternatives. You can have something called a directed trustee. Now the advantage to a directed trustee is this is basically somebody you're putting in place who can manage the money part. They deal with the finances, your child can deal with the day-to-day cleaning up. They can literally be the person going to your house cleaning up, they can be the person dealing with the grieving side of it, and the letting the family know what's going on side of it, and the personal side. And again, you can then have somebody doing the money side. The other advantage to this is, in most cases when you have what are called co-trustees, you've named two people to do the job, they are liable for each other. Basically, if you mess up, I now am on the hook for you doing something wrong. The advantage with a directed trustee is it's separate liability. So if the person messes up the money, your child is not now liable for that. Or if your child does something wrong, the professional who you've named is going to be very thankful that they're not liable for what the child did. So it separates it, but allows everything to continue moving forward. Now, this is, again, not applicable for everyone, but this is one of the solutions we can offer if that is a question for you. You can also have a professional fiduciary. Now, the difference here is they are liable for what the child would do if they were named with a child. So there's that string attachment that some people do not want to walk into. Now, other people say, no, I do want them attached because if one does something wrong, I want them to be holding each other accountable. So there's, again, different ways and reasons you would want each one of these, but truly, it's one of the things that stops people from moving forward with planning, is they don't know who else could be their representative if a child or a friend or another family member isn't who they would have or want. Never get to hear that. Say a little prayer for whatever's going on out there. Now, I mentioned if you have a piece of property or you have more than that $184,000, a will is not enough to protect you. And so we've been talking about trusts. But even if you have a trust, you actually will still have a will. The reason is this is a safety net will. This is not a standalone will. This is one that works with your trust. The purpose of the will primarily is to say, if as life has gone on, actually let me back up for a second. One of the things with a trust that needs to be done is certain assets need to be titled in the name of the trust. So after the trust is established, you're not quite done with the homework component of it. There's certain assets that go into the name of this document. Generally speaking, those are checking accounts, savings accounts, and non-retirement regular brokerage investment accounts. It also includes your real property. Now, I separate out the real property because typically Kopenberger has taken care of the real property piece, but it's on our client to do the bank account side of it. If those things are not done and you pass away, those assets in theory could still be subject to a full probate. But I say in theory because that is where this pour-over will comes in. The purpose of this will is to say, even if I had made a mistake or I forgot to put something in the trust that should have been, the court, I'm telling them they don't get to have full control over that asset. I still have to go to court and show them this will and show them the trust and say, my will says, kick it all back, you don't get to touch it. But ultimately your will is saying to the court, they do not get to control the asset. It needs to go back to what your trust laid out and the terms that you had already set. So it saves it from going through the entire probate process and again ensures your wishes are ultimately the ones carried out. Now the next thing I want to cover are your emotional treasures. So this has a lot to it. I'm going to quickly go over a few of these, focus a little bit more on one in particular. Your social media, your digital accounts, your email accounts, your iCloud with your photos. If you pass away and someone doesn't have passwords, a lot of times those assets, those treasures, are lost. Because especially with Apple and these other companies, their privacy rules are extremely strict. If you don't have the authority or the access or the password, they won't let you into those accounts for the person that you've lost. I know when my grandma passed, the best thing we had was her password for her phone and the iCloud account. It was for her phone. It allowed us then to contact her friends to let them know she had passed away and to let them know when a funeral would be. For her iCloud, it allowed us to find the photos that she had. And again, without having those passwords, those things would have just been gone. The other thing with an iPhone really quickly is we can help you walk through this a little bit more in depth, but you can set what is called a legacy contact. And I believe this is the same for Androids as well, but I have an iPhone so I can speak on that one definitively. A legacy contact is somebody who's different than an emergency contact. It is somebody who has the authority where if you were to die, they can access your iCloud, your phone. They have then the Apple permission to let the person into the accounts that they would manage. Now, not everybody's going to want that, but I know if I passed away, I don't want all of those photos to just never be seen by my family again. And so you can set those legacy contacts. Cryptocurrency, this is another big one.
Legacy or legacy?
Legacy. Yes. Not lazy, not a lazy contact. I hope they're not lazy. The next asset is your cryptocurrency. So if you have cryptocurrency, you likely know that if you lose your code, your key, your chain, whatever the thing is that would open up the account or get you into the value of the asset, that if you don't have that, it's essentially gone. Now, that is not the same for every single piece of cryptocurrency, but for the ones that it is, again, it is imperative that you have put that code in a place that the person could find it, or you have prematurely given it to them. Obviously, there is risk of writing those things down in a place that someone can find. But unfortunately, what has happened is people haven't, they've passed away, and then that value is gone. Because at this point, for most of the types of cryptocurrency, there's not a recovery ability at this time because it's not managed how your cash and your other assets are. So it is imperative that you have that somewhere, unless you are okay gambling that that value would disappear once you passed. The one I want to focus more on right now is the family history, the mementos, the things that are intangible but cause, unfortunately, a lot of fights and cause a lot of emotional distress after somebody has passed away. What we hear constantly from people about the stuff is, my kids don't want it, they've said to donate it, get rid of it, we don't care. And we pretty consistently push back and say that is very likely true because you are sitting there with them. But unfortunately, when someone dies, their stuff becomes all we have of them at that time. We obviously have our memories, but from a tangible thing to hold, the stuff becomes the loved one. And if you have multiple beneficiaries, if you have multiple children, when somebody attaches an emotional value to something, they unfortunately can fight tooth and nail over it because it's emotional. It is not logical. And we have sadly seen families get fairly torn over the stuff. It's not actually the finances that you would have expected. So one of the things that has been built into the Kopenbarger Trust is what is called a memorandum power. Basically, if you have one of our trusts, that means if you have an item that you want to designate to someone specifically, you don't need us to do that for you. You can literally use a handwritten letter that says what the item is, who it goes to, that you sign and date. If it is in your handwriting, you do not need a witness or a notary at that point. If you have a lot of things and decide to type it, you'll need witnesses or a notary to essentially authenticate that you really were the one who typed that list up. But this allows you to designate items and cut that fight over an item out. The other thing we encourage you to do is write things down, record yourself, somehow capture the value of things that have emotional value. We hear way too frequently about people where they think something in their parents' house may have been a family heirloom, or they think it may have had some sort of emotional value, but they don't actually know because the story was not written, it was not told, it was not recorded. And again, unfortunately, those are things that once a loved one is gone, the story dies with them if it hadn't been preserved. So if you have questions on how to do this or what types of things to be looking for when it comes to emotional value items, we are more than happy to talk to you about that. Because one of the things we do take seriously is helping keep families together and again, helping preserve those legacies. And this is one of the foundational ways to do it. And bluntly, not every attorney will take that time. But Lloyd knew the value of these items, and again has instilled that in the rest of the firm, that these are the things that matter, and these are the things that go beyond just the financial value. Okay, deep breath, everybody ready for the next section? So that's the foundational information. So now what I want to transition into is the life changes that may have occurred. So when you have your estate plan, it is not a fixed moment in time. What that means is when you establish your plan, your life continues on. So when you set that plan up, maybe you had minor children, maybe you were single, maybe you were married and now you're not. Things transition, and as a result, your estate plan needs to go along with your life. So what are we talking about? Again, did you have minor children that are now adults? Well, they may not now need guardian provisions. They may be the people you're looking at serving in the different roles that you had originally filled with someone else. Are the beneficiaries still the same? Did you not have children at the time? Or do you now have grandchildren? Did you have charities in there from 20 years ago that you no longer support or that are no longer in existence? Have you changed churches? Do you still want, if you've left money to your prior church, for it to go there? Or do you want it to go to the church that you're currently attending? These are the things with beneficiaries we really encourage you to look at. And are you moving? So, God love the state of California. We do have a lot of clients who, as especially they're retiring, look to move out of this state. Couple things there. One is we can help with that transition out of the state to help ensure that when you get to the new state, if you've bought a new home, if you have new bank accounts, the reminders of making sure those assets are protected. But the other great thing for the estate planning attorneys is we can continue to be your attorneys. So that is one of the biggest questions we hear when people are moving out of state is, do I now need to find a new lawyer, or can I still work with you? For estate planning, we can continue representing you. The other thing is we work with a large network of attorneys across the country. And so if you do move to a state that we know has very specific rules, in most cases we already have a relationship with an attorney who can help you there. And if we don't, we can help ensure that you find someone who will provide the same quality that you've come to expect with us. So if you are planning to move, please do come and talk to us about that. If you have moved into the state, it is also then a good idea to come and meet with us to make sure your documents are fully compliant with California. So if you've done the opposite move, which is not as common, we can also assist in making sure you have documents that are really going to be effective and accepted here. So, one of the biggest life changes that is you've got to come and see us is either you've gotten married or you've gotten divorced. If you have gotten married, we need to make sure that you either say, I'm not providing for my spouse in your trust, or we say, I am, and here's going to be the provisions. It has to actually be put in writing. Now, if you're married, you also have now a few additional decisions to make as far as the type of trust that you have. So one of the things we talk about at our consultations is what is the type of trust? And there are numerous types. One of the ones that we talk about is called an AB trust. The purpose of the AB trust is multifold. One is, it actually can protect a decedent's estate from remarriage. What does that mean? When you set up a trust with a spouse, if you have a joint trust, it's all in one pool. You have a one-stop shop that you both manage. But what happens if you die before your spouse? Do you want your spouse to have full control to say what's going to happen with your half of the estate? Very bluntly, do you trust that if they got married, they wouldn't change your half in a way that you would not have wanted? If you have a question as far as, would I want them to have the full control if I predeceased them and they remarried? We can set up protection where they can have benefit of your half for themselves, but they cannot give your half to somebody you don't know or do not want. So remarriage is often a concern that gets addressed with this trust. The other thing is, what is the size of your estate? Now, right now, when we're looking at the size of your estate and tax concerns, we're looking at estates that are about $14 million. For most people, $14 million is a very high threshold. We're falling below that, so we're not going to be concerned about what is called federal estate taxes. However, especially when people own homes in California, those homes may have appreciated significantly more than you're factoring in to the overall value of your estate. And the $14 million exemption that we're under right now is a number that is able to fluctuate based on the administration and based on what is called the sunset provision that is applicable as of now at the end of this year. The sunset provision will basically slash the $14 million in half. Now, $6-7 million is still a significant amount. But again, when you start factoring in home values and other pieces of your estate, people start encroaching on that more than they may realize. And so with an AB trust, you can actually double the exemption that you were entitled to. So this is again why we encourage people to come in, and we say every 3 to 5 years to check in with us. Because as your estate changes, as your life circumstance changes, and as the law changes, we need to make sure your estate plan still covers what you need today and predict now for the future from this point. The inverse is also true. If you have gone through a divorce, it is imperative that you come in and update your documents. If you had initially set up planning with a spouse and you are now divorced and you have not updated it, they could still be entitled to make your medical decisions. They could still be the person who would be entitled to manage your money if you can't. And ultimately, they're very likely still the beneficiary if you die. Most people who go through a divorce, there's a pretty big reason you went through a divorce. It's not because you still like the person. So putting them in those positions of power, especially when you're vulnerable, and having them as the ultimate beneficiary, very likely does not match the intent that you would want at that point. So again, these are a couple of the life circumstances where come in and see us to make sure things are still relevant. Next, we look at your children. So I mentioned before, not all beneficiaries are created equal. Not all of the beneficiaries do you just want to hand the keys over and say, okay, good luck, do what you want with the money, we're just handing it off to you. A lot of times when we're looking at children, we ask the question of, do you want your inheritance to those kids to go outright? So where literally you're saying, here's the money when I die, Godspeed. Or do you want to put in what are called protective lifetime trust provisions? What those protective lifetime trust provisions are there for is to insulate the inheritance from any predator who would otherwise want to take it. Sometimes that's the child themselves. Sometimes you're putting it into this protective lifetime trust, and you do not want them to manage their own inheritance. You want to put someone else as a manager over that trust for their benefit, so that the money can still be used for them, but they again don't actually have the keys to the kingdom. But it's also to protect the inheritance from outside predators. We live in a community property state. What that means is if you acquire marital assets or if you have a separate property asset that you combine during the marriage, if you went through a divorce, that money then can be, half of it can be taken by that now ex-spouse. With these lifetime trust protections, if your child went through a divorce, their inheritance stays their inheritance. It cannot be taken in a divorce proceeding. It also protects it from creditors, lawsuits, the IRS, and even bankruptcy. So if, for example, they're out driving, there's a car accident, it's catastrophic, fully their fault, and their insurance isn't going to cover the entirety, their own estate may be subject now, but they can still retain their inheritance to now fall back on and not lose everything. The other thing is, if they're married, we'll play a more happy scenario. They're married, they stay married their entire life to that spouse, but they end up predeceasing the spouse. The spouse that has outlived them decides they want to get remarried. Do you want to risk the inheritance you left for your child and the spouse you may have loved and known now going to someone you never got to meet in a new family? Or do you want to ensure it would go to your grandchildren or to another family member or to a charity that you would have wanted it to go to? So again, it has that generational component as well to ensure your wishes of where that money would go and what it is used for are actually carried out. Now, one thing I want to very strongly emphasize is, it sounds silly, but an email isn't enough. A handwritten note is not enough. If you have a change to your documents and you think just jotting something down, even signing it, is going to be fully effective or valid, you are unfortunately mistaken. We hear that a lot of, I just want to change a trustee, I just want to cut out a beneficiary. Can I just go in and start handwriting all over those documents? I implore you not to do that. Please come and talk to us. People who do that can be at risk of a number of things. One is the change that they wanted just flat will not be accepted. It wasn't valid, so it'll revert back to what you had already put. But in some cases, if you write too much over those documents, you can fully invalidate a document. So you may not even have the reversion back to what you'd had. You may now have just undone any work that you had put into effect. Now, I know when we talk about coming in and doing amendments, the next question is, what will it cost? And yes, unfortunately, in most cases, when you're making changes, there is going to be some amount of cost. But Lloyd said it when I first started, and it is something that has stuck in my brain more than a tick on a horse, sorry for the expression. And that is, you do not know the cost of an estate plan until you need it, and that is not when you want to find out what this plan cost. What that means is, it is in almost every single circumstance more effective, it is less costly to do it right than to gamble and risk it later and either put the cost on yourself or ultimately on your family. So when you have these changes, come in and meet with us. There are certain things clients can do on their own, but it is a very limited scope. Come and meet with us. We can walk you through what the changes that you can do are. We can walk you through what the changes an attorney needs to do are. And ultimately, we do walk you through the cost component. But again, I implore you, don't just be jotting notes down and hope that those are going to be valid.
Question.
Yes?
So, is the whole country that you don't have something notarized to change? Is that a sticking point?
Not having it notarized is a component, but estate planning on its face, even attorneys who practice other areas will look at estate planning and say, I can do that, it's easy. All I need to do is I need to write my wish down, have it notarized, or have a witness. The problem is estate planning is complex. It is why we spend, as attorneys at Kopenberger, our entire year, if we're not meeting with you, we're researching, because it is so complex. And so if things are not done precisely, the court will take that as an opportunity to say, that wasn't correct, we now need to be involved. The other issue is, forget the court component, think about your beneficiaries. If somebody goes in, and especially if they're changing distributions and they're just jotting a note down, if somebody's been cut out or had their amount reduced, if it is not valid, I promise you in most cases they're fighting that. And in a lot of cases they're now winning that. But even if they don't win, you've now opened the door to an unnecessary fight that doing it correctly would have avoided. So it's more complex than, just a notary or not. The rules, especially in California, are strict. So I keep throughout this mentioning the word legacy. So the reason legacy is so important is, again, I'm bringing it back to Lloyd. Lloyd started this firm because he has a firm belief that every single person has a legacy and that legacy matters. And your estate plan is a foundational part of helping ensure that legacy is preserved and protected. Putting your wishes in writing, making sure they are in a way that will be carried out, is the way that you ensure that legacy continues. It is something that unfortunately, not a lot of people, not a lot of even attorneys focus on, but it is something that we foundationally focus on here. It is why we bring up your stuff. It is why we bring up those emotional treasures. Because again, it's not just the dollar figure that you can put on your estate. It's who you are, it's the values you want to leave, it's the ensuring your family doesn't fall apart due to unnecessary conflict after you die. So it is something that if you're with us and you're passionate about making sure that those conflicts are avoided, that things are done correctly, you have found the right firm to work with. Again, another deep breath for everybody. Let's move into the next section. So those are the life changes that may precipitate you needing to come in every 3 to 5 years, or even more frequently, to check in and make sure things are done. But the law changes as well. Now, our job here at Kopenberger, we firmly believe, is to educate our clients on what those legal changes are. We do not expect you to be paying attention to what's going on in the estate planning world or in the probate world and know when it's time for you to come and see us. Our job is to give you what has gone on, which, as you can see, has been a significant amount in the last 5 years. Our job is to educate you on that and see how do some of these things apply to you, and are there additional changes or planning procedures we need to put in place. Now, this section we go over a bit quicker because, again, not all of this is going to be specific, but if something flags for you that I need more information, take advantage of those free consultations and really take advantage of that video library, because we have done a slew of webinars and videos on these topics. The first one, if you've been to a seminar in the last couple years, you may be sick of hearing about Prop 19, but a lot of people still don't know what Proposition 19 is and what it did. Proposition 19 went into effect now, 4 years ago just about. And basically what it did is it eliminated property tax inheritance benefits for anybody, with one exception. The only people or only property that has any property tax transfer benefits is your primary residence to a child who also claims it as their primary residence and lives in it indefinitely. If they decide 5 years after you died they lived in it and they now want it to be a rental, year 5, it gets reassessed. So it has become extremely restrictive, and it's become problematic for anybody who has more than one child. Because the scenario that we have seen is, your trust says you're leaving it to 3 kids. They distribute, at the end of the administration, a deed is written out where all 3 kids are on it, they own it. A couple months go by and one goes, I'd really like to live there. Do you guys mind if I buy you out? I can give you cash or other monies. And they go, sure, yeah, buy me out. I'd love the cash. I can go do whatever I want with it at that point. And they now are transferring interest from child to child. Unfortunately, if you have 3 kids and the one is going to keep it and 2 are now transferring their interest to the one, 2/3 of that property tax would now be reassessed. But there's a way around that. The way around that is by putting those same terms into your trust through what is called right of first refusal. That right of first refusal can literally say, okay, we have this piece of property, but we know child A is the most likely to want to own it and live in it. They live in the area, they don't have their own home, they want to be here around family, great. So in the trust you can say, child A, you have the first right to buy out your siblings before that deed has ever been drafted, so that it still qualifies as a parent to child transfer. Child A still has to pay the other 2, so they still get their equal portion, but again, it keeps then the entire property tax what you paid, not what the new value would be. Now, if child A gets to the point that decisions being made, they go, I'm not really in a position I can do it, or I don't want to at this point. You can have child B have that same decision, they can say no, child C has the same decision, and if they all say no, they can choose what to do with it, but it builds in the choice to help preserve those property taxes instead of having that automatic reassessment. The one other way that you can get around Prop 19 is with the use of an LLC, but this is again extremely restricted. If you are going to buy a property, you can set up an LLC that purchases the property, but it has to be done as the purchaser. If you already own the home, if you've already bought the home, you cannot retroactively put it into an LLC. So this has to be done ahead of time, and again, the LLC has to actually have the funds to purchase that property. But if you are going to be looking at purchasing a home in California, a rental or whatever it may be, absolutely come and talk to us about LLC protection and if that is something applicable to you. The next big change deals with Medi-Cal. So I'm going to give a quick history on Medi-Cal, but talk more so about what is the relevancy of it today. Medi-Cal is a program that is not age-based, it is needs-based. Basically what that means is it's looking at, do you have a physical or mental condition where you need more advanced care? Historically, Medi-Cal has then looked at what is your asset level. Do you have essentially too much in assets to qualify financially? You might have the physical or mental need, but you may not qualify financially. Now, historically, we had an asset protection Medi-Cal trust that we had for 10 years that worked extremely effectively, helped preserve estates for our clients, and allowed them to qualify for Medi-Cal so that Medi-Cal could assist in paying for that new high level of care that was needed. But Medi-Cal changed fundamentally at the beginning of last year. They actually decided they were going to throw out the asset requirement, and now we're looking at income. So instead of looking at what the size of your estate is, they're looking at, for the person who needs the care, what is your monthly income at that point? So that does a few things. One, it opened up the program to significantly more people because not everyone has the income per month that Medi-Cal is looking at. But for some people, they're now having to consider, how do I preserve my income to protect it from Medi-Cal so that I can still have that assistance? And the reason this is important is if you have not looked at the cost of what long-term skilled nursing costs or what in-home care costs, I don't know many people who can truly afford that on their own without completely depleting estates. And that was why Lloyd initially had us create this trust at Koppenberger, is he watched people who were going through these high levels of care and just run through estates and end up destitute. You've paid into Medi-Cal anytime you have paid taxes. And so again, as I mentioned, every law is written with a loophole. And Lloyd dove into those loopholes and had his team dive into them to ensure that his clients didn't have to be in the position of either I don't get the care I need or I'm depleting my entire estate taking care of that loved one. So if Medi-Cal is in need and you're concerned that it won't cover you because your income is now too high, we have since created an income protective trust. So that is something that we can also assist you with if that is a concern. If it's even a small concern, I recommend come in and start the conversation now, because again, it's better to pre-plan than emergency plan. Another big law change was the Secure Act. Now, there's a few slides in your packet that go more into what you would need to talk about with a financial advisor, and you're going to hear from a financial advisor here this morning. There were a lot of changes with your retirement planning. The Secure Act fundamentally changed how long you can contribute to, or how old you could be contributing into retirement, what year you had to take your required minimum distributions, catch-up contributions, again, all of the things you should really talk about with an advisor. But it also changed your beneficiary benefits. By that I mean, historically when a beneficiary inherited, and I'm not talking about spouses or any of the exceptions on this slide, but historically when a beneficiary inherited a 401k or an IRA, they had to assume minimum distributions, but they were not forced to take anything above that. Now the rule is they have to take the entirety of the inheritance from that account within 10 years of your date of death. So not only do they have the minimum distributions, they have to withdraw the principal over that 10-year period. Now they can decide how to withdraw it over that 10-year period, but it does of course increase the tax liability on those accounts, which truly I advise you talk to an advisor about what your strategy should be, because those tax consequences for you or for your children can be significant. But why does this apply to your estate planning? So going back to those protective lifetime trusts, if you already have those trusts in place, or if you're looking at setting up one of those trusts, one of the questions we ask is, do you also want your retirement accounts to have those same protections? That when your child inherits from an IRA, do you want that money also protected from divorce, creditors, lawsuits, etc.? Most people say yes, but then it is imperative that your retirement language in your Kopenberger Trust complies with the Secure Act. Because if it does not, there can be significant tax consequences of having those monies put into those protective lifetime trusts. With the correct retirement language, with that updated section, that money can receive that protection without incurring anything additional over the 10-year window of tax consequence. Yes?
Would our documents like from last year already have this, or is this active?
If they were brand new documents, they would have had this section in it. If it was an amendment, I would need to see what we amended to know for sure. But if you had, yes, a brand new Kopenberger document last year, these absolutely should have the correct retirement. Again, we're happy though to take a look. We generally can answer that within a few seconds, in fact, of looking at your documents. Another tax, again, I mentioned taxes apply to us whether we like them or not, and here's another one. But this one's actually a little bit more of, as weird as it sounds, a happy tax. And that is dealing with gifting. A lot of people are unaware that, for one, the gift tax exclusion goes up every single year. It generally goes up $1,000 every year. So what that means is this year, you could gift to any individual $19,000 and never have to tell the IRS. Now, gifts include, if you bought someone a car, that goes against the 19. Technically, birthday gifts and Christmas gifts goes against the 19. But any gift, if you're under in that year, gifting a person under $19,000, you never have to tell the government you did it. The thing that most people don't know, though, is if you go over the 19 for that person, you still are unlikely to have to actually pay any kind of gift tax. You may have to tell the IRS that you went above the 19, but they will take the amount you went over the 19 and deduct it from what is called your lifetime exemption. Right now, your lifetime exemption is just shy of $14 million. So unless you're gifting the excess of 19 up to $14 million, you're still not going to actually pay a gift tax. This, again, is complex. I'm doing a very high-level overview. If you are someone who gifts on a more grand level, especially per year, do come and talk to us to make sure you're filling out the right things and that things are being done correctly. But most people do not fall into a gift tax concern, which allows them to be a lot more altruistic without being concerned about the government getting a piece of it. Yes? The 19 is per person. So every person, so my husband and I could gift Lloyd $19,000 and my husband could gift Lloyd $19,000. So it is, yes, per person, not per couple on a tax return. The next piece is, again, going back to the federal estate tax. So as I mentioned, the federal estate tax exemption, it matches the gift tax exemption, is about $14 million. Again, as I said, most people are not worried about their estates being over the $14 million. But, as I also said, that is a moving number. So when a spouse passes away, one of the things we look at is what is the size of the estate at that point? Did it hit the entire exemption, or were they under the exemption level? If they are under the exemption level, the surviving spouse can use what is called portability. Basically say, I'm going to take what they didn't use and I'm going to add it into my estate. So that way, if my estate either continues to grow or the exemption when I die has been slashed even further, the odds are pretty great that between my exemption plus my spouse's unused exemption, my kids and my estate are still not going to be subject to any kind of federal death tax. So this is something, if you have unfortunately lost a spouse or at the point that a spouse passes, we recommend you come and see our administration team sooner rather than later. Not because portability has an immediate, you need to make a decision, but a lot of times when someone's grieving, these are the decisions that get kicked down the line, because who wants to talk about portability when you just lost a spouse? But it is important to come and talk to us because we can flag for you what is important. And if you have a relationship with us, we can be paying attention to deadlines so that you can be focused on the grieving and we can be focused on the legality and getting things done correctly. So that is very much where we encourage you. Take advantage of the fact that we have a team that can walk alongside your loved one or walk alongside you.
Is this directly tied to the AB trust?
Portability is not tied to the AB trust. It is separate from that. So this is especially if you don't have an AB trust, but even if you do, something that spouses can take advantage of. It is, there's a similarity, but the AB will double it. This you're only getting to, this is the addition of you're taking what they didn't use. So you could get even more. Yes? So that sunset provision is what I mentioned, that at the end of this year, the exemption of $14 million currently is going to be what's called sunsetting. That means it's going to essentially be slashed in half. Now, with the administration that is currently in effect, there is a very good chance that will end up being extended. But right now, it is still set to be cut in half at the end of this year. We'll keep everybody updated if that gets pushed. This next section, I'm not going to go into much detail, but I mentioned we have a business and tax department and business and tax attorneys. So there's numerous slides that go into the detail of what this summary slide hits. If you have residential, commercial, any type of property that you are leasing out, it is imperative that you are staying up to date on laws. In 2024, there were numerous changes that could affect what your rights are, or in the other side, what your tenants' rights are, especially when it comes to evictions. I don't know how much you heard, but during COVID, eviction procedures became a nightmare for landlords. You basically couldn't evict someone. And those restrictions have not loosened or lightened a whole lot, and in some cases have gotten even tighter. The other thing is if you're going to be doing upgrades, changes, you're doing repairs to your leased properties, there's new photo requirements. What that means is you have to take a before photo and then an after photo to help prove to insurance or whoever the organization is, most likely your insurance company, that you actually did the work that they are now going to pay for. So again, come and talk to our attorney if you have questions on that. If you have your own business, there are additional reporting requirements at this point. One of them is called the Corporate Transparency Act. Now, that is an act that is being challenged in other states. However, it is an act that we have to follow. It has very strict reporting requirements that essentially say if you miss certain deadlines, you're fined it's now higher than $500 a day for every day you miss that reporting deadline. This includes LLCs. So if you have an LLC, you need to make sure that these reporting requirements and deadlines are met. It's not suspended. We have that they do not have to enforce it, but they have currently decided they are going to continue enforcing it. Yeah, it's a don't have to, but.
There's a website, there's a banner that says it's challenging court
Don't have to, but you can, where you can and should. And part of the issue is they can turn a requirement on at any time with no notice. And those penalties will then be in effect. So yes, it is being challenged. Like I said, it can, but frankly should report. Yeah. Employment laws, our newest business and tax attorney to Kopenberger, she's been practicing with she's been in corporate law now for 7 years. She's also able to help you if you have employees, go through and make sure your employment contracts are still up to date, to ensure that your employee requirements are being met. So if you again have a business where you have employees, that is something that also can be covered here. All right, I am at the end of my section. I'm now going to bring up Lifestyle Financial. Lloyd, do you actually want to introduce Lifestyle? Okay. So Kopenberger was started by Lloyd Kopenberger. Lifestyle Financial was started by his wife, Laura Kopenberger. Laura has since handed the reins over to their grandson, Charles, or Chaz, as some of you may know him as. And one of the big things with Lifestyle is they are very focused on families. A lot of people don't want to frankly talk to advisors because there's a concern of, again, I'm not uber wealthy, so why would someone even spend the time with me? Charles and actually my husband, Zach, who's his business partner, very much want to take care of everybody. They want to help you strategize at any level that you're at, how to accomplish your goals and how to accomplish the legacy that you are looking to set. So we have, again, obviously there's the bias of the family relation, but I promise you we would not have them here speaking to you unless we knew the quality and the care that they give their clients. With that, I'm going to hand it on over.
Thank you, Victoria. Good morning, everybody. I just want to say what an absolute pleasure it is to be with you here today, and thanks for joining us. I'm Charles. I am the head of Lifestyle Financial since 1995. Lifestyle Financial, founded by my grandmother, as Victoria said. Since 1995, Lifestyle Financial has been in the business of helping individuals, families, and small businesses identify and accomplish their financial planning goals. When my grandmother brought me under her wing and gave me this opportunity, both of my grandparents told me, your job is taking care of people and ensuring they're taken care of. And as long as you continue to serve people, you will do very well. And so that's exactly what we've done. We don't work with numbers, we work with people. And many of these people we've formed long-term, close relationships with, and that's really just a wonderful feeling when people come into the office and they feel like family. And so we offer many different services, and it goes way beyond investments and financial plans and financial advice. I will briefly go over this slide, but basically anything financial. We specialize in financial planning, retirement planning, and wealth management. We do other things outside of that, but those are our main focuses and specialties. We specialize in retirement planning, financial planning, and wealth management. So it's not just investment focused. The fact of the matter is most people that we meet initially don't have a financial plan. And that's for many reasons, but financial planning isn't something that people get excited when the weekend comes. I don't think I've ever met when I asked what your plans are for this weekend, they said, I'm going to update my financial plan or create one. And that's because financial plans take time, effort, and energy. And so one of the benefits of having a financial advisor is one who's going to help you plan and create that and implement it. Every year we go see our doctors, our dentists, our estate planning attorneys to update things, but many times, other than reviewing investments, we're not updating or creating or implementing a financial plan, and that's a mistake because finances are something that's very important to be going over and reviewing. Our responsibility at Lifestyle is to help you go over that plan and implement it. The markets are not fixed and are constantly in change. And so as you progress through your journey and get closer and closer to retirement, it is important that things are updated and changed. Most people aren't going to sit down and just watch the stock market constantly. I mean, you'll go crazy if you try to do that and then have any type of life outside that. But that's what we do. For those who haven't met Victoria's husband, Zach lives, breathes, and eats the stock market. He will call me and text me sometimes at 5 in the morning and say, today's going to be a really good day, and here's why, and I can't believe what the futures are doing, and you know, he's really excited about it. But we make a really good team, and he's just a wonderful individual. So if you get the opportunity, I hope you get the chance to meet him. I want to comment on something that Victoria said before I go any further, when she talked about some of the changes in the Secure Act, and specifically when she was talking about some of the changes as far as having to take out some of the inherited retirement accounts over a specific period of time. And really what that kind of underlines is the benefit of having a financial advisor. So we are a resource to our clients. And one of the areas that we shine is when there's a financial change or a big financial, anything that's going to happen, whether it's a purchase, a change, or an inheritance that comes into play. Specifically, what I'm thinking about is I had a client whose mother died, and when they were going through the paperwork, I had walked her through, okay, you know, she has a retirement account, here are the rules, and we discussed their situation. Well, her mother had a financial advisor who was just going to help her with the paperwork, and she was trying to push for my client to just take everything out in a one lump sum. And I explained to her, had she done that, she would have paid more than half in taxes. Well, what we were able to do was look at the situation and find the most tax efficient way of pulling out the money. Because I explained to her, we no longer have to take out the required minimum distribution every year. My client was 5 years from retirement, and I said the most efficient way is to leave it invested. We wait 5 years. We have to take it out completely within 10. But now, the remaining 5 years, you're going to be retired. We take the majority of your retirement income from that account, and we pay the least amount in taxes. And so she avoided a potential disaster because she would have ended up writing the government a huge check. And I'm sure, like every proud American in here, everybody loves paying taxes almost as much as I do, right? And so, really, again, when you have a financial advisor and there's a change coming, I had another client who called me, hey, I'd like to buy a vehicle, or I'm thinking about purchasing a home, or I'm thinking about selling real estate so that way I can get claim the exemption. You know, is that smart to then replace that property? And so when you have a trusted advisor that you can talk through these things with and really come up with a good strategy, that's the main value of a financial advisor. I mean, yes, it's important to have someone who goes over the investments. Yes, it's important to have someone who goes over a plan, but someone who really can understand and look at the whole picture and say, okay, you may not want to do this, and here's why. Because at the end of the day, you're the boss, and it's completely up to you. But, again, when you have a trusted advisor who can advise you and help you make the best decision, that's really the value there. Now, briefly, I'm going to talk about the markets. So, inflation is still persistent. My goodness, has anyone tried to buy eggs? I think it's up to a gold bar at this point. But inflation is slowing down a little bit, but we're still seeing it in the markets. We had an election. We have a new president. And as a result, we're seeing in the markets just some changes. And so while our crystal ball is broken, what we are seeing or what we foresee is going to happen is a continuation of the first administration. Tax cuts, a more business-friendly environment, broad deregulation. And so all of those things are positive as far as the markets are concerned. And we think that 2025 is going to be a good year. Now, does that mean it's going to be without hurdles? No. If anything, politics is certainly not boring right now. And so we're not sure what the international landscape is going to look like. We're not sure what's going to happen with the tariffs and the other things that are happening internationally. So we are watching it. We're still in the very early innings, but I think 2025 is still going to be a really strong year, even though there's a lot of things that still remain with a little question mark next to them. But as things are developing, we see a lot of good things. And that brings us to, this is a new investment cycle. So more than a few people have commented to me and asked, why is the market so volatile? And I agree, volatility has increased. But what we're starting to see is a return to more of a normal market cycle. So we had an abnormally low amount of volatility for a really long time, and people got used to that. And so I think it's good to have volatility. And while it would be great if the market just went straight up, that's not the way the market works. And there's an analogy I like specifically to talk about this, and that's, we don't want everybody on one side of the boat, because what happens when everyone's on one side of the boat? Boat flips. And this market's the same way. If the market's doing nothing but going straight up, it's eventually going to go straight down. And so seeing the market go up and down with a tug of war of people having different opinions is a very good sign. But it's important to stay invested. The important thing is just monitoring the financial plan and ensuring you're not taking out too much risk. But at the same time, you can't time the market. Sometimes people get lucky, but for the most part, market timing doesn't work. You're rewarded for time in the market. I met with a lady a couple weeks ago, and she was complaining that her investments weren't keeping up with the market, and she didn't know why. And after taking a look under the hood, so to speak, I told her why. And the fact is that she had pulled everything out of the market. She put things in CDs, and she didn't realize that they were just rolling over to whatever the prevailing rates were. And she was, at first they were paying about 5-6%, and then they started rolling over and they were paying her 1 or 2%. And when the market was doing really well, she missed out, unfortunately, on the performance. But I told her, you need to be reviewing this, and she didn't have an advisor who was helping her, so we were able to outline some areas that could be improved. But again, you want to stay invested if you can. So I'm going to wrap it up, but if anybody here thinks that there's something that we could help them with, if you'd like to sit down with us, it's complimentary. It just takes an hour or so of your time. So we have a booth out there. Come say hello, and I hope you enjoy the rest of the seminar. But thank you again for joining us, and I hope you enjoy the rest.
Thank you very much, Jazz. I want to take just a moment to introduce our next speaker. This is a man that I've had, I almost say, a lifetime relationship with. I met Brad in the 90s when he was just starting Pacific Justice. That organization has been consistent throughout the time of his leadership, and he's structuring it to continue to be an organization that will have an impact on our society in, I believe, a very positive way. One of the things that I'm concerned about with the results of the election is we're seeing a return, I believe, to some of the cultural values that I was raised in and I believe are essential for a healthy society. But sometimes it's easy to put your foot off the gas when things are going downhill. And remember, the people, the forces that were bringing these changes that I personally found to be an anathema. I still believe boys are boys and girls are girls, and never the two shall meet except in marriage. Now, I know that's an archaic view, but it's a good view. Having shared my life 65 years with the most wonderful woman God ever created, that's my value. But Brad has consistently stood up for the values that I believe make society work and work well. And so I commend him to you today, and I commend his organization to you. Now, I don't let very many people talk to you as my clients, because I don't know everybody, and sometimes people have agendas that are quite different than what's good for you. And so I don't try to choose who is who and what's what. But this man I have confidence in. So Brad, without any further delay, let me turn this mic to you, and God bless you.
Thank you. Thank you very much. Thank you, Lloyd, very much. And I just first off wanted to thank Lloyd and Kopenbarger because they have been such a blessing to our work at PHAI. But I also have to comment on the fact that, when my wife and we wanted to have our will and our trust done, we had I know a lot of attorneys across the country. We have hundreds of affiliate attorneys across the country. We defend religious freedom, parents' rights, safety, like we have a lot of affiliates though. And we chose the best firm that we knew to do our estate and trust. And it's a law firm of McGilly, Cowan, Kopenbarger. And Dewey, Cheatham, and Howe. No. Kopenbarger. Because they are the best, and Lloyd is very humble, but his people really have high expertise. I started Pacific. How many heard of this before? Raise your hand. Okay, good. And how many of you got this in your packet? You should all have it. Anyone ever get your packet? If you don't, just raise your hand, and David in the back will be happy to make sure you have one. But I found it back in 1997. At the time, I was regional coordinator for another organization for the West and Western states, and coordinated litigation. And then they decided to shut that office down, so I started Open Pacific Justice Institute. Gave the good Lord just a few little requirements: free office space, free computer system, keep me on the radio stations for free. There were 2 at the time. We have to be in the black in just 3 months, and I'm never going to charge anyone. I thought that was a very reasonable, business model. Well, God came through on all of it. And it made it really clear that it was his baby and not mine. And now, fast forward, we have offices in 36 offices in 26 states. And we have over 200 cases in active litigation. We have radio stations that have exploded in terms of covering our material. So the DACUS report is heard on over 1,000 radio outlets across the country without charge. All of our office spaces without charge. In fact, the radio show is really good. I mean, the guy who does it is awesome. He's my favorite person. Okay, it's my show, but it's a good show. All right. Anyway, but let me let you know where we are right now. The limited amount of time I've got left. We see incredible opportunities for our children today. But we have a limited time. We have to take advantage of it. We have a Supreme Court that is the most pro-parents' rights, pro-religious freedom, pro-sanctity of life in the history of the United States. It's unbelievable. And then on the same time, on the administrative side, we have some executive orders coming down with regards to parents' rights. These are very powerful. And we even have an office in Delaware working to promote parents' rights protections at a national level to counter what we're dealing with at a state level. Washington State, I just saw this in the news. They're pushing out a bunch of bills in Washington State that are going to be anti-parent, strip parents of their rights of their kids in so many different ways. And so we're going to be battling that at the legislative level, and then we're also going to be fighting it in the courts with the right plaintiffs on a constitutional level. But the great thing is we've got a great Supreme Court, and we're going to have more judges appointed now that I'm very optimistic about. I also think Sotomayor, I think there's a good chance she'll be replaced in the next 4 years for different reasons. So there's a lot of optimism I have moving forward. Some of our challenges real quick. When they shut down the churches and the synagogues, we were the ones that led the charge, and we were the first to get an order from the Supreme Court ordering Governor Gavin Newsom to open those churches and synagogues now, and he did. And it was a real blessing to be able to do that. And now we've seen also a lot of people purged from their jobs because of their faith involving the pandemic. We've stepped in. We led the charge in defending them from losing their jobs. People in the military being discharged, etc., to make a real impact there. Then we had a case. In fact, we had a case dealing right now in New Jersey, where the Attorney General has ordered that all teachers have to use certain pronouns, even if it violates the conscience of a teacher, to encourage confusion. Think about it. And they have to be willing to lie and cover things up for parents. Not on our watch. So our attorney and Karen White, who heads up our office in Trenton, New Jersey, we filed a lawsuit against the Attorney General there. We're taking that on head on. Michigan pastor and his small group from his church were using the FACE Act, were put behind bars, and our pastor was actually awaiting sentencing. Why? Because he was peacefully there on the property of an abortion clinic, not keeping anyone from coming in or leaving, just there praying. And that was enough to violate the FACE Act for the Department of Justice. He was waiting a sentence of up to 11 years behind bars. 11 years behind bars. We stepped in, we represented him, and we were waiting for the sentencing, and they've all been pardoned, and which is, I think, a real asset, a real good thing. He's now back with his 3 boys and his church. Then we had a preschool under attack. Part of the reasons they're under attack in San Diego and shut down was because they have the children are compelled to sing Christian songs and hear Bible stories. 4-year-olds. So the court says, no, not the court, but the state of California says, no, you can't do that. Any preschool, even if it's church run, you can't do that. So we don't get angry at Pacific Justice. We just sue. So that's what we've done. And then we've got a lot going on. Also, one more, and that's dealing with the attack on the Jewish students and the young people across our country. I was stunned. I thought I never would see this in the United States. Massive mobs harassing some Jewish kids who could not feel safe to go to their classes. And we made a public pledge that we will defend every single Jewish student in the United States without charge, public schools, colleges, to make sure that they're protected against this. And we're doing that, and we already had our first victory out of Santa Barbara. So anyway, this is it's a big success, and we've got more cases coming on. We have great opportunities. What we're doing on the legislative side, we're working with them to get great things passed on the federal and the statewide. We're real encouraged about that. We got 6 states to pass laws saying boys can't compete in girls' sports and go into girls' locker rooms, and that's before the executive order. So we're seeing a lot done, and we're going to make a lot of progress by God's grace. Finally, let me just say this. And if you want to fill this out, please, it means a lot to me personally. I'd love to keep you guys updated with what we're doing. So at the very least, pray for our work. So if you can fill this out, and if you want to fill out the top half, that's fine. But I'd just love to keep you updated. It means a lot to me. Let me just say this final word, and I'll be in the back at during the break. It's great that you're here. Protecting your assets for your children is being responsible. It's being a good steward. It's thinking ahead. It's a loving thing to do. But make no mistake, those assets won't be worth much to your kids if they don't have their freedoms. We at Pacific Justice Institute are committed to making sure they keep their freedoms. Thank you very much. God bless. Oh, question? I'm sorry.
So your organization sounds a lot like the American Center for Law and Justice, ACLJ. Have you heard that?
Yes. And how are we different? I'll just real quick. Good question, though. Real quick. So we're different in a number of ways. Number one is we have offices all across the country, a huge footprint, unlike any other organization in the country. And the reason is for the other reason that we're different. We don't just cherry pick high-profile cases, and they've done great work. But other organizations, they look at the big game cases. We have a ministry mindset. Our goal is to make sure that everyone gets help, that no one is left on the side of the road. That is our commitment, and by God's grace and His miraculous intervention, we've been able to do that with a very, very high success rate.
Do you have a business card, phone number?
Yes, we do. And also, we have a success rate, more than 90% success rate in our litigation this last year, which is another awesome thing that's happened. And then also check us out on ChooseCharity.org, I think it is. It's a great objective place to look, and they look at efficiency, transparency. Great way to objectively look at different organizations. I use it myself, but to save you a little time, we have the highest rating of any comparable organization of our kind, both integrity, transparency, and efficiency. So thank you. Good question. I could have paid you money for that question. That was a good one. God bless you all. Thank you very much. And thank you, Lloyd.
Thank you very much, Brad. The thing that impressed me about Brad and his organization is he's right, they don't cherry pick. They meet the battle wherever it is being fought. And there are some really fine organizations involved in the same work, but none of them have the commitment to dealing with boots on the ground as opposed to fighting the big battles from the air that Brad Dakins and Pacific Justice had. I want to spend just a couple of minutes dealing with something that I need to cover, make sure it's covered, because we're getting ready to make some major changes in our Access program in the future. How many of you here today are members of Access now? Okay. Listen, but don't get involved. For those of you who are not Access, and let me ask how many of you are here. Okay, several of you. If you are ever interested in the original Access program, and what's special about it is it's a lifetime membership. You buy in one time, you're covered for as long as you live and as long as your spouse lives, and your children can use it after you're gone to partially satisfy some of the costs of the trust administration and some of the other issues that might arise. I encourage you to get involved in that program while it's still available, because it's going to be phased out except for the people who are members of it within probably the next 4 to 5 months. Now, the other programs that are going to come on are good programs. They wouldn't be presented by Copenbarger and Copenbarger if they weren't. But that original program that I created over 25 years ago, it's the one thing in my career that I've done that I have never received a personal criticism of. Now, maybe some of you said it under your breath, but you've never let me know about it. And it has blessed many, many families and many, many people by giving them the opportunity to protect loved ones in their lives, by giving them the opportunity to cover grandchildren with powers of attorney for health care, to encourage children to come in and get their estate plans done. I can't tell you all the ways that people have used that Access program to bless other people in addition to protecting themselves. And so I want to encourage you to consider, if you ever wanted to be part of that Access program, now's the time to get involved in it, because it's going to go away and the new program is going to be more expensive. It's going to have more protections, but it's also going to have monthly fees associated with it. And I told my staff, I believe in the new program, but I want to give all the people who have been members of the Copenbarger family up to this point an opportunity to be part of that original program, which was such a blessing, in my view, to so many people during the time that you've served as part of our family, and we've been privileged to serve you. So that's the thing I want to bring to your attention, because it's something that's going to be very important that within the next few months to get joined, if you want to join, because once it goes away, it's gone. And so now, those of you who are already members, it's going to be with you as long as you're alive. It's going to be here after you're gone for the benefit of your children to settle your estate. So I don't want to make it sound like we're taking anything away from the people who are existing Access members. As a matter of fact, we're adding some benefits to the original program for those of you who have been our friends and who have been members of that Access program all these years. So again, I wanted to make that very clear, because I've been telling you we've been working on this Access program now for a couple of years, trying to figure out how to make it work into the future. because the world has been changing. And so, but I don't want to not cover the people who've been part of our family for so many years, and I want to give you that opportunity before the changes that are going to have to be made occur.
Thank you.
Victoria?
And to re-emphasize with that monthly component, if you're already an Access member before these changes go in effect, you would not have to pay for the new low tier, and you would not then be subject to those monthly fees. So that's, I really want to make sure that that was emphasized. But it really is an incredible program. Yeah.
Sorry, I'm asking a question. So this benefit passed on to our kids or just the spouse?
Chris, I'm asking you this. I'm putting him on the spot. Our CEO's in the back. The question was, is this a benefit that will transfer to kids or only to a spouse?
There is a component of the new program that can transfer to kids, yes.
Okay, so I probably will talk to you.
Chris will be at the Access table. That's actually what we're going to transition into is our break. So Chris, our CEO, who's been working with Lloyd to get these new tiers into effect, will be at the Access table, which is where you picked up your packets. So please feel free to stop by there to get more of that those questions answered. You know you're a member, frankly, if you have one of the badges like this. If you have a sticky sticker, you're not in the Access program. If you have one of these badges, you are.
Unless they just registered.
Unless you just registered. But we have your number. We can let you know if you are or not. Yes? We're looking at the next between 4 to 5 months they'll be in effect. So by the second quarter, we're expecting that this program, these new ones, will be being rolled out. Yep. We're putting the final touches. If you sign up for the current Access benefits now, yes, when the new program, the first tier, when that is launched, you would immediately get grandfathered into that first tier. Yes, with the new benefits. Without the monthly either. If you do now, if you sign up once it's in effect, there is a monthly component that has not been in effect.
We're coming back in. Let me make a statement about the provision in your workbook that we're not going to cover today. And that is on advanced planning. We have never talked in our firm about the estates we handle that are substantial. And the reason we haven't is we don't look at people based on the number of zeros in their bank account. And we never have and we never will. But we have been given the privilege of representing a number of very wealthy people, and for my entire legal career, I have helped plan very large estates. Again, you've never heard me talk about it in the past. I'm only talking about it today because we're not going to talk about these subjects. But if you're in a situation where you have an estate that is greater than the amount you can pass free of federal estate taxes, you need to talk to us. If you are selling a valuable piece of property that has a significant capital gain, you need to talk to us. If you're selling a business, you need to talk to us. And so, remember, we are more than we say we are. And that's a fact. And I don't apologize for not talking about things that, some of the things we've been blessed to have the opportunity to do. But I do want you to know that if you have a major issue that's going to come up, talk to us before you do anything. You can't imagine how many hundreds of thousands of dollars I've seen clients lose because they didn't pick up the phone and call us and tell us what they were thinking about doing and let us tell them the things they need to be concerned about. And by the way, that's one of the benefits of that Access program. You can pick up the phone, and what does it cost you to call and talk to us if you're an Access member? Zero. So anyway, I'm taking valuable time from a lovely lady, and so let me turn it back to Victoria, who's going to introduce our next young attorney.
and she's going to talk to you for a few moments.
All right, thank you. So we did, as you'll notice, jump a quick section because, again, we are on a time constraint, and we want to make sure you get to hear from Megan Wilson, who is our trust administration attorney here today. She has been being trained by James Kosarev, who, if you know him, is an incredible attorney, and we are extremely thankful to have her give you a quick insight into what's the after part of an estate plan. Megan, here you go.
Okay, hello and good morning. Now, I know you guys are used to James, so let me just start by saying those are some big shoes to fill. I wear a size 6 heel, so I'm going to do my best. I want the same energy and the same love and the same welcome. Can you hear me? Yes. All right, great. So we're going to go ahead and just get right into it. So the difference primarily between estate planning and trust administration is that estate planning is happening while you are all alive. Trust administration happens when you pass. So more than less likely, you personally might not be my client, but your trustee will. Okay? So what I do primarily is work with the trustees, work with surviving spouses on how we can effectuate what you've put in these plans. How do we go about distributing assets? How do we go about moving assets, assigning assets, things of that nature? So, trustees, very, very, very important topic, right? We're trusting that this person is going to be right and do right by your assets. Take a look at this picture right here. A lot of the times, this is what's going to happen with your kids. I hate to say it, my brothers and I are kind of the same way. Thankfully, my parents are still with me right now, but I know that when they pass away, we're gonna bicker about some things, because I know my dad's got a sweet Corvette we're all gonna fight over, right? So these are the things that your trustees are gonna have to deal with. How do we deal with bickering between the siblings? How do we deal with who's gonna get the house, who's gonna get the cash accounts? This is the stuff that your trustee's gonna have to do. So making sure that you have a good trustee is really, really, really important. One thing I'd like to say that most differs between estate planning and trust administration is it makes my job a whole lot easier if there's just one trustee. I know a lot of you are thinking, well, I have 2 kids. I would like my kids to just work together. Well, let me just give you an example here. I'm gonna use myself as a trustee, and I'm gonna ask you to be a trustee with me. If we have $1 million in the house, $1 million in stock accounts, we have 2 kids. I'm a child, you're a child. If I say I want the house, you say you want the stocks, everything goes well. Is that usually how life works? No. Right. So if I say I want the house, my sister says, well, I want the house too. Now we're stalemated. And this is actually what happens, right? And unfortunately, that's when the attorneys come in and we have to try and parse out what's going to happen and who's going to get what and how are we going to distribute this. But unfortunately, that comes at a cost. So what I like to tell people is, even though you might think I want both of my kids to be co-trustees, really think about what that means if they disagree on what's going to happen. And maybe possibly put that plan or whatever you're thinking into your estate planning, okay? So, co-trustees, probably not the best idea. One trustee that you trust, probably much better, right? Now, let's also think about our beneficiaries. What if you have a beneficiary that is incapacitated? What if you have a beneficiary that has a substance abuse problem? What if you have a beneficiary that, like myself when I was in my younger days, and I know what you're thinking, how old are you? I'll never tell. But what if you have a beneficiary that, like my younger days, was significantly frivolous with money, right? When I was 20, if I got my parents' estate now, I would have been in Vegas. Not a great idea, right? Not a great idea, not what we want from our beneficiaries. So how do we put these things in place? These are things that you guys need to get into your estate plans now, because when it comes to me, I have to follow exactly what's inside of your trust. So does your trustee. That is my requirement as your administrator, as your attorney. That is their requirement as your trustee. Whatever's on that paper is what's going to happen. We cannot deviate unless we go to court, and if we go to court, it's going to cost thousands. And it's just not necessary. That's why we're here to begin with. Does that make sense? Yes. Fantastic. Now, what does this process entail? A lot. But to make it short and simple, we have to update land records, right? So if you're trustee, let's go back to that one example. Me and my sister are co-trustees. If I'm getting the property and mom and dad's name's still on it, I can't sell it, I can't own it, it's not in my name, so we have to update the land records. We're gonna have to tell the recorder's office, the assessor's office, who's now in charge, who's passed away, and what's going on. We also have to send out notices now. Notices are quite interesting. If you have an instance where you have multiple beneficiaries and you've changed those beneficiaries, all of those people are gonna get notice. Right, so let me give you a great example because this can be problematic and I see it play out all the time. You write a trust and you're initially like, I just want to give my 5 kids my inheritance. This is everything. I love them. They're my pride and joy. Fantastic. You get older. 1 kid's doing everything. 4 kids are MIA. Now you're like, you know what? I kind of want to give more to the 1 kid that's really been dumping their savings and their life into me. So I'm gonna weigh the scales a little here to make it more fair, right? Makes a lot of sense. It's common sense to me. Now, if you make that change, when they get that trust and they see the amendment, it was all 1/4, all 4 kids. Now it's 90%, 10% split between 4 different siblings. If you think that's not going to litigation, you think again, okay? I need you guys to really understand here. When siblings get these notices, when beneficiaries get these notices, whether or not they've been written in or written out, they're going to have questions. Those things need to be handled by the estate planning department, right? So right now, if you're making changes, if you do them appropriately, we don't have to show those changes to the beneficiaries. That saves a lot of time, a lot of heartache, a lot of questions for my department. Okay, so these are just things I want you guys to think about. If you're thinking about making changes, that's fine. But make sure that you're doing them appropriately so that when we administer your trust, we don't stir up any problems that we don't have to. Any questions with notices to the beneficiaries? Fantastic. We're also going to move forward to a lot of the trustees' duties. I'm not going to sit here for too long because as the picture shows, it can be frustrating. It can be a bit daunting. There are some very simple, basic ones that I want you guys to remember. 1, your trustee's duty is to be loyal to the trust. What does that mean? They can't favor themselves. They can't favor one beneficiary over the other. They can't favor outside sources. What their job is to make sure that what's written down in your estate plan is what actually happens. Let me give you a prime example. If I have another beneficiary, I'm going to use you as my beneficiary. 1, 2, and let's pick one more, 3. The 3 of us are beneficiaries. If I'm also the trustee, right, my duty of loyalty is to the trust. But I can't favor myself over the other beneficiaries because I am the one that's tasked with having to do the trust administration. If I say, well, I want the house and there's enough cash to buy them out, they'll be fine. I don't get to make that decision unilaterally, right? That's favoring one beneficiary over the other. Can't happen. What's also nice though is if you make sure you write in your estate plans what your plan is for that home. So I don't even have the room to think of those things, right? So these are the things that I want you guys to be thinking about because the more detailed your estate plan is, the easier my job is. And that's really essentially what I'm up here for, right? Just an easier way to do my job. Okay. Another thing I'd like to talk about is conflicts of interest and commingling funds, right? Trustees will often come into a position where now I am responsible as trustee of your trust to maintain your assets, to marshal your assets, to get control over your assets so that I can make distributions. What if I take control over your assets and then I go out and buy a new car? Does that look suspicious to any of you? Right. So there's a reason why there are these laws and these duties. It's because so long as the assets are not commingled, it's very easy to tell whether or not I bought that car or the trust bought that car. Right? So beneficiaries go and they say, "Ooh, Megan, you didn't have a Corvette when you started this process." And I go, "Yes, but I do have a job. You know, here's my bank account, here's where that came from." It's very easy to see these things, but if I don't have it, if I have the accounts commingled, and I did add the estate's assets to my personal assets, then it becomes a really hard thing to parse out, and that's where courts get involved. That's where beneficiaries really start saying, "Hey, this is inappropriate behavior," and that's where we really come in and we say, "Hey, make sure that you're doing this appropriately because we don't want any problems." Okay? These are just a few of the duties. Obviously, there's a lot. I'm not going to go down all of them because I don't want you guys to fall asleep. I want you guys' energy. I want you guys awake. I just want to make sure that the things that I'm saying are clear so that if you have any questions about what's about to happen after you pass away, you know who you can come to and how you can, and what questions maybe to ask, okay? All right. Important. The other entities that you're going to have to give notice to, not random, it's just required by the law. You're also going to have to give notice to the California Franchise Tax Board and the is going to have to do. They're also going to be responsible for receiving information and correspondence from those entities. Don't really think about is that while you're alive, your social security number, when you pass away, you can no longer use your social security number because you have passed away. So we have to obtain what's called an identification number, or to now identify your trust asset as a separate asset from the trustee who's going to be taking over that asset. Okay? Yes.
All right, so person passed, are they assigned?
Right, right, yes.
And no longer the social security number, what is the
passes away, you have to apply for a new taxpayer identification number. It's called a TIN or an EIN, entity identification number. And those are applied. We are going to, yes.
Does that also
No, if your trust has two settlors on it, the surviving settlor, well, it depends on the trust, but to be blanket statement, if you have a surviving spouse, the surviving spouse's Social Security will take over the trust for the most part. If you have an AB trust, which we've been discussing quite a bit here today, then your A trust. Okay, great question. So now we're going to talk about a little bit briefly about taxes. I'm not going to go into too much detail. Seeing me afterward, or maybe even possibly scheduling an appointment, but your trustee is really going to be responsible for filing the personal income tax returns, fiduciary income tax returns. Remember, right now while you're alive, the trust operates under your Social Security number. When you pass away, the trust will have its own identification number and it'll
my wishes. I'm hearing you say, this person that will be administering my wishes through my trust. Before they can do anything, they've got to apply to the IRS for a new number.
Well, when you pass away, this is when should reach out to our office and we will walk them through this process. Very much so. I don't recommend ever applying for asking a CPA would be advisable, but certainly asking our office to do it is what I would say. I have seen countless individuals try to do it online by themselves, click the wrong button, and then if you guys are familiar with working with or staying on hold for any kind of government agency, it will take you a successor trustees, the IRS, to get changes fixed because they thought they could do it themselves, and that's fine. If you're well versed in this area, I would say go ahead and do it. It's not super complicated, but it's an easy process to mess up, and if you mess it up, it has very significant implications. When you pass away, is going to have to obtain an EIN. I would highly recommend having them reach out to our office so that we can do that for them. Okay?
Sorry, I apologize.
Yes.
So what happens in a situation where a state
EIN at all times, because it's either seen as an entity through the settlors, meaning they have a social. If it's not assigned a new one, then it's going to be. Okay, all right. So those are the income tax returns. Now let's talk about federal estate tax. Now, again, unless the estate is worth over $14 million, it's not likely that this is going to be applicable. But if your estate is more than $14 million, then you're going to have to file, or your trustee is going to have to file that tax return. Portability election is something that surviving spouses, it's a conversation that we have with surviving spouses. Again, if you want to elect for a portability election, you actually have 5 years to do it. So I always tell the surviving spouse, hey, you have time to make this decision. If you're still grieving, please take your time and do that. But this is something that you should consider, especially if your estate is relatively high. Yes?
If that $14 million comes down to $7 million, are you going to let us know?
Of course. Our office will definitely let you guys know. Okay. Yeah. And then when somebody passes away and you come in and you meet with us, that's one of the first things that, or not the first thing, but one of the things that we highlight during the meeting is, hey, this is something you need to be starting to consider and starting to think about now. Okay. Income property tax, income tax basis. This is also something for capital gains purposes. Now, when you pass away, your property is going to get a new basis as of your date of death, right? So what does that mean? Now, I'm terrible at math, so please don't hold me accountable if you guys are math people. I have a few clients that are engineers and they terrify me. If you have a property and you purchase it initially for, let's just say $100, because again, I'm terrible at math, then you sell it for $1,000. I know these are really tiny numbers, please just bear with me. You have $900 that are subject to capital gains. Does that make sense thus far? Okay. Now, when you pass away, that purchase price of $100 changes to the fair market value of the asset as of your date of death. So now let's just say your asset at purchase was $100, but when you pass away, it is now $1,000, and your surviving spouse, or maybe your trustee, turns around and sells that property immediately for $1,000. There is no capital gain. Fantastic. Now, let's just say in the instance where we have two spouses. First spouse sells the house, or first spouse passes away, there's a new step up in basis value as of the new date of death. Second spouse passes away, there is a second step up in basis value as of the second spouse's date of death. That is to benefit your kids. That is to benefit any of the beneficiaries in the estate, yes.
So spouse A passes, and that changes the base value. Does that change the property tax for spouse B?
No. So when you pass away, so the question was, just so that everybody's aware, if spouse A dies, does that change the property tax? Now, there's a difference between property taxes and capital gains, right? So property taxes change when there's a change in ownership, right? So if you pass away, there's an exception there for interspousal transfer. So if you pass away, your spouse can then keep the same property taxes that they have. Now, here's where property taxes come into play. If you pass away and it goes to your spouse, no problems, no harm, no foul. Fantastic. They haven't hurt us yet. But when you pass away and your your kids go to take that property. Now there's an actual change in ownership. When there's that change in ownership, then it's going to be triggered. Now, if that child lives in that property, then they can maintain the property taxes. If they move out of that property, then there's a problem. Okay? It's going to be reassessed. All right, I'm going to start moving a bit faster now. We talked about some of the jobs that the trustees are going to have to do. They're going to have to change title on assets. Which means they're going to have to take the title from you as trustee of your trust to them as trustee of the trust, and then possibly to your kids as owner of the new asset. Okay, let's now talk about also what it means to be responsible for all of these different types of assets. If you have a trustee and you are not telling them the types of assets they have, it becomes a witch hunt. It is an absolute disaster trying to figure out what somebody owns if you have no idea what is in their estate. So, what we ask is that you provide somewhat of a list on your Schedule A if you're drafting it, or on some kind of document that you provide to your trustee saying, these are the assets and the institutions that they were with. Think about your financial accounts. If we don't know what bank you work with, how are we supposed to know to go and contact that bank to collect the asset to give to your kids? If we don't know the retirement plans that you have, how are we supposed to do those things? Same thing with life insurance, business interests, and personal property items. Please make sure, please make sure that you are doing these things, okay? Thank you so much. If you have any questions, I'll be at the back. I'm gonna pass it off. I'll meet you at the end.
She's done. Megan, and you can find her card out in the back. I'm going to talk very, very briefly about the defending of legacies. And basically what it means is that we have an enforcement branch. You put together documents for you to be able to continue on after your death to get your desires. If your documents are complete, we can defend them. If your documents are not complete, we can't. So basically, what I want, Lloyd says, we're done. If you have questions, see us afterwards, please. And right now, we're going to invite Dave up to the stage, and he has got some gift cards.
Okay, we get a drawing real quick. Who has a number? Some people were entered into it, so it's only for a special crew that brought guests. 5801-591. Who has the ticket that ends in 1591? You do? Okay, come see me. I got some gift cards for you. And that's it. Thank you for coming today. There's another event taking place, so we would ask you kindly to come out as soon as possible and meet us in the courtyard, and you can hang out there with us as long as you want. We'll be out there. You can talk to the attorneys. You can talk to anybody you want. And there's still food. Take food home. Good afternoon. Goodbye.